Good morning. I'm Wade Scott, and welcome to the Delaware Elder Law Center, where we help families protect their life savings from the devastating cost of long-term care. This morning I'm going to talk about how to make known your wishes for medical treatment should you find yourself in certain conditions. And typically this is done by someone while they're alive and healthy, and they go to an estate planning attorney and they put in place a document known as the Advanced Healthcare Directive. Now this is a document where you name your healthcare agent, which is critical. It also enables the patient to put in writing how they want certain conditions handled if they find themselves in one of them. Now, legally, these are known as qualifying conditions. The first one is permanently unconscious, which is not a coma. It's a condition that the patient will never recover from. They'll never know they're alive. I think of it as like brain dead. The other one is if someone forms some type of terminal illness from which there's no medical expectation or medical probability that the patient will recover. In the document you can make three choices. One is, I want the doctor to do everything possible. The second one is, I don't want life artificially sustained, but I want to pick and choose which medical interventions I want or don't want. I don't want a machine breathing for me, but I do want resuscitation. I want water, but I don't want food. And the third choice is, I'm just going to leave it to my agent to make the decision real time. Now, one of the shortcomings of this document is that it's produced as a result of a legal process known as estate planning. It's not an enforceable medical order for treatment. The doctor may decide not to follow what you've put down. And I think the COVID era really points this out. Let's say your directive, you've chosen, I want some interventions, but I don't want any. Or you picked one of like, I want the doctor to pull all the stops out, no matter what. And you're a COVID patient, you're so sick that you're admitted to the hospital and there's a shortage of ventilators. You're 65, you have comorbidities, heart and lung problems, and the directive says you want intervention. The doctor says, no, this is a terminal condition and I'm making the call that this patient's not going to recover anyway, so he's not going to get a ventilator. So that's the main shortcoming. Now, there are medical orders for treatment, and an example is a patient's in a nursing home, and the facility doctor, at the patient's request, signs a do not resuscitate order. Well, that order is legally enforceable and has to be followed if the patient's in that facility. If the patient ever leaves the facility, that order expires. In other words, the general medical order doesn't follow the patient from one treatment setting to another. And that can lead to some bad consequences for some people. So the Medical Society of Delaware and the Delaware Legislature wanted to fill these gaps, to deal with these situations. About 4 years ago, the legislature put in place a new healthcare law known as the DeMost Act, Delaware Medical Order for Scope of Treatment. And this medical order is available to a subset of patients who are defined as seriously ill, medically fragile, and no one would be surprised if they passed within the year. And, you know, that's a perfect description of a COVID patient. These medical orders are legally enforceable. The doctor has to follow them. The medical order, once it's in place, follows the patient from one treatment setting to the other. So, for example, if the patient says, as a result of the DeMost order, they don't want to be resuscitated, they're not going to be resuscitated no matter where they are, in the ambulance, at home, in the hospital, because this order is in place. The process is, for this subset of patients, the doctor meets personally with the patient face-to-face, and they fill out the order that sets in place what the patient wants in light of their then existing medical condition. You know, these conditions aren't limited to permanently unconscious or seriously ill or a terminal illness, sorry. It's broader than that. It includes those two, but it's broader than that. And that way you've put into writing in an enforceable way that, for example, this is just an example, if you're a COVID patient, you're critically ill, you're in the hospital, and the discussion is we have limited ventilators, and here we have a patient over 65 with comorbidities. The probability is that even if we put him on a vent, he's not going to live. So this patient doesn't get a ventilator. Well, because of the medical order for treatment, your advocate, if you can't communicate, who's the agent that you named in your advance directive, has a basis for appeal and to be your advocate. And that's much better than having the advance directive, which is instructive only and not enforceable. So then the issue is, well, who's on first base? In other words, if a patient has both documents, which one controls? And it's the most recent one. And from a reality logical point of view, usually the DeMost order is the most recent in time. Now, you can't download this order off the internet. Only the doctor has access to the form that is produced by the state, and it has the state seal on it. You know, you just can't download it. You have to get it through a medical professional. This is an interesting topic. I hope you found it useful. If you have any questions, please call me. We're here to help. Thank you.